petition is allowed, it will be remanded to reconsider. One second. How's this? What has happened to that? Okay, to list it tomorrow. Tomorrow. What happened? Contract amount? What? What has happened? It was regarding contract amount payment only. Okay, on the prayer of Mr. Upadhyay, the learned counsel, appearing for the petitioner, appearing for the respondent, irrigation department, which is not objected by the counsel appearing for the petitioner, let the matter be listed after the BU vacation. 8 and 9 both. Huh? Yes. Resale affidavit for what? You have already filed. Okay. You are appearing for? Okay. On the prayer of the learned counsel appearing for the respondents, which is not objected by the counsel appearing for the petitioners, let the matter be listed after the BU vacation. Or let the matter be fixed on 27th. 27th April. Okay. Six. Yes. You'll be filing a rejoinder. The learned counsel appearing for the petitioner submits that she'll be filing a rejoinder to the affidavit in opposition filed by the petitioner in the instant case. Raised for 2 weeks' time. Let the matter be listed after the BU vacation. No, after the BU vacation. Item number 38. You are appearing for whom? It is the learned counsel appearing for the petitioner. Petition raised for 2 weeks' time, which is not objected by the counsel appearing for the respondent. Let the matter be listed after the BU vacation. MS Deborah, the learned counsel appearing for appears for the cooperative. When did you file it? But there was no office note of filing it. I've checked it. There was no office note of filing it. So what is to be done? Okay. You are appearing for the petitioner. The MS M. Kotoki. R. Kakoti, the learned counsel, appearing for the petitioner, submits this. He has filed an additional affidavit in the instant case. However, the same is not on record. Let the matter be listed after a week. After a week. You are appearing for whom? What has happened? You have been taking time in this matter. Oh, let the matter come. No, let the matter come. Let the matter come. Mm. But they have been taking time. I mean, for 3, 4 times, I mean, they have already taken time. Who is your senior? Mr. A. Goel is always out of the station. Last 3 occasions you have taken time. I have seen the file. Personal difficulties cannot go on and go on. Let somebody else appear then. Last 3, 4 times you have taken time. I've checked the file. I've checked the file. Okay, right. On the joint prayer of the council appearing for the respective parties. Let the matter be listed when. Okay, he's saying after the vacation. Okay, let the matter be listed after the vacation. No more time. No more time. Okay, item number 22, right? Entry amount as so passed earlier shall continue till the next date of listing. Item number 39. Okay, on the prayer of the learned counsel appearing for a petitioner, appearing for the petitioner, which is not objected by the counsel, appearing for the respondents. Let the matter be listed after the ensuing leave vacation. MS so-and-so, the learned counsel, appearing for the petitioner, submits that they would like to file a rejoinder in the instant case. Prayer is allowed. Let the matter be listed after the ensuing leave vacation. 20. Yes. What has happened? The money have already given the money on 30 days, the concerned mistake officer. I have the instruction. Can you take up this matter? Okay, we'll take it up when the matter is. You are appearing for whom? Okay, the learned counsel appearing for the petitioner submits that praise for some accommodation in the matter as she needs to complete her instruction. Full stop. Prayer is allowed. Let the matter be listed after 2 weeks. 36. Yes. Item number 36. Yes, what has happened? Hmm. Because the land counsel appearing for the petitioner submits that the land counsel conducting the case is not available today and prays for some accommodation. Let the matter be listed after the view vacation. The interim orders of past earlier shall continue till the next date of listing. 46. Yes. Hmm? For what? So this is this a ground to mention the, mention the matter? The matter is today and he has gone home. Okay, they'll heard Mr. So learned counsel appearing for the petitioner submits that to the conducting counsel. What is his name? Mullah. So Mullah has to had to leave for due to certain medical emergencies. Let the matter be listed after the view vacation. 32. Yes. This come for what? Okay. On the prayer of the learned counsel appearing for the petitioner, let the matter be listed after the ensuing view vacation. What has happened to this? Hmm. Have you whom have you informed? Who is appearing for the pollution? Let the matter come. We'll see like what is happening there. Let the matter come. Thirty. On the prayer of the learned counsel appearing for the petitioner, let the matter be listed after the view vacation. After the view vacation. Mr. Borua, there was a matter, this item number 7. No, that's fine. I mean, they're saying that they are filing some rejoinder or whatever. But one thing I just wanted to understand. See, this is a stone crusher, right? And stone crusher and pollution department, stone crusher usually what are the kind of this thing pollution. Pollution is two kind. One is air pollution and other is the noise pollution. And you go and inspect and submit a report when the stone crusher is not running. What is this? Let the matter come. You'll have to explain this. I mean, in a stone crusher, a report, wait, in a stone crusher, a report has been asked about the pollution, to complain about the pollution. And you go there and inspect it when the crusher is not running for a month and you submit a report that all parameters are fine. Is this kind of a report? Is this kind of a joke or what? Then hmm, inspect it. It's correct. No. In the side inspection, you found that this is they have stopped it for some maintenance or something for 1 month. For 1 month. So you go when the crusher is not running and you submit a report. What kind of report is this? You'll have to explain this, Mr. Borwano. You'll have to explain this. No, you'll have to go when the cursor is running, not when the cursor is not running. How will you find out otherwise? They are not functioning. No, they stop for 1 month, and you go during that point of time when the cursor is not running. That cannot be done. That correct directions of the code only you have gone, but if, I mean, Mr. Borua, tell me one thing. If you want to find out whether the cursor is doing some noise or doing some pollution or not, you will go there when it is not functioning, and you submit a report. No, you have been directed, but you have not explained. I have seen the report. You have not explained that. You have not taken time that like we should go in a time when the cursor is running. I mean, you go when the cursor is not running and you submit a report, that will not do. I mean, otherwise, how will you find out whether there is a pollution or not? Cannot be measured. I mean, if the stone crusher is running, if there is a pollution, you'll find out when the crusher is running, and you go there when the crusher is not running, and they said that we are not functioning for last 1 month. You are happy with that. You come back and submit a report before this court. That like 2021, we have gone there, we have inspected that point of time. All parameters are fine. Is this kind of a report? Is a responsible pollution board? There is no, don't take about direction of the court. Court's direction is perfectly fine. Court wanted it to look into give a report, but report when you will give, when it is lying down. When you should have you should have taken some time. You should have taken some time. Then you submit a report that no, 2021 we have gone there and we found it perfectly fine. Is this kind of a report? Cannot be like this. That will be brought on record. That will be brought on record. You bring it on record. When did you file it? So you bring it on record today. We'll take it up the matter. We'll take up the matter. Mr. Borua will have to seek instructions. Similar matter was there. Financial year is different, but the ratio is same. But only because of PSU, you are not supposed to submit 25%. Is this the ratio? Hmm? But that doesn't the court. I mean, have you given any undertaking? They will pay it. Let me see the order. The same day order. 532026. Okay, this coordinate bench is already passed. But Mr. Datta, the ratio was little bit different. And in that case, there was an undertaking given by the councils to the court. Whether you have given any undertaking here? No. But anyways, coordinate benches. Okay, heard Mr. and Datta, the learned counsel. appearing for the petitioner, also heard Mr. B. Borua, H. Borua, the learned counsel, appearing on behalf of Mr. B. Gogoi. B. Gogoi, the learned additional AZ, some appearing for the state respondent. The case of the petitioner is that the petitioner has filed a revision petition, a revision. Now you write like this, the present petition has been filed challenging the impugned order dated 5/3/2026 passed by the Additional Commissioner of Taxes, Assam Korbhavan Dispur, Guwahati, on the revision petition filed by the petitioner for the assessment year 2015-16, 15-16, under the Assam Value Added Tax Act 2023, directing the petitioner to deposit 25% of the disputed demand for admission of the revision application. Full stop. The learned counsel appearing for the petitioner submits that since the petitioner is a government undertaking and in terms of the decision of the Honorable Supreme Court in case of BPCL versus Commissioner of Sales Tax and others, reported in 2018-17 VST 162 SC, as well as the order dated 31/8/2017, passed by the Assam Board of Revenue, in an appeal preferred before it by the petitioner, herein the pre-deposit amount of 25% is not mandated to be made by any state government undertaking, like the petitioner, for admission of either an appeal or a revision preferred by it before the tax authorities. Therefore, he submits that the order dated 5/3/2026 is required to be interfered by this court in view of the aforesaid judicial pronouncement of the Honorable Supreme Court, as well as the order of the Assam Revenue Board. Assam Revenue Board, full stop. Mr. Borua, the learned counsel, submits that he will take instructions in the matter. In the matter, full stop. It is also seen that in a similar case, that is WPC number 1729/2026, in bracket you write Assam Gas Company Limited versus State of Assam and others, wide order dated 25/3/2026. The same order dated 5/3/2026 was interfered by this court, taking into account the aforesaid aspects of the matter. Notice was not issued in this matter earlier. So you'll take instruction, it can be disposed of probably. Let the matter be listed after when 6/4/2026, 6/4/2026, by that time, the learned counsel appearing for the respondents will complete his instructions and intimate the court about the status, full stop. In the meanwhile, till the next date of listing, the further proceeding in the revision petition. What is the revision petition number? Is there any number? A revision petition pending before the file before whom? Superintendent of Taxes. File before the learned Superintendent of Taxes will remain state. Will remain state. Yes, Mr. Ali, what? Hmm. 6671. He has registered already, and his name is not deleted. I mean, his D voter was not Deal. Ah. Hmm. 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 No, he is marked as D later on. Hmm. 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 Now, which is the document which shows that like you have been marked D voter? Is there any document? The page 20, what is that, Mr. Ali? Hmm. So 2018 they were registered. Hmm? Now what was this order of 2018? That's a different revision. Hmm? But but earlier order. No, but this order of this thing 25/7 to 89. It says 66 this thing. Hmm. This is only the list of declared unpressed declared. So from here he can't make out whether he's a unpressed. He's not whether he has been marked D or not. How do you know? I mean, how the court will know? No, unpressed. The unpressed is different and marking D is different. Your allegation is that though you have been registered after the order of the court, your name has been put under D, correct? So from where you are saying that your name has been declared? Hmm. No, now to take instructions by them, that you'll have to produce certain document. No, from where now? You are saying only from this document that you have been declared D. But page 20 NRC will not. The Mr. Payang can be probably can get some instruction. So you have mentioned that he has been declared as one is declared foreigner, one is declared for foreigner, descendant of declared foreigner. Now he is saying he is D voter because he has already registered. Ranjit Paul is registered. Hmm. Hmm. What is your instruction, Mr. Sarkar? See, I mean, there is a process. No, no, after, no, after, no, after what? No, see, after registration of your name, uh, 10 years you are barred, right? So, no. After 10 years, whether you have applied for the inclusion of name, what is the process? Is it direct entry into the voter list, or you'll have to apply to include? Hmm? No, election commissioner. The election commissioner is saying that they'll have to apply for this. Is it so? Hmm. Hmm. Then I should be included. No. Why election commissioner, Mr. Sarkar? I mean, you have been debarred from voting for 10 years because of due to your registration. Correct. Now, after 10 years is over, you need to file an application before the election commission saying that 10 years period is over now. Now I'm eligible for franchise. So my name should be included. Whether you have done so. That they are saying that election commission is saying so. No, automatically how? Now you cannot produce any document which shows that you are a D-voter. Only document you are saying that like relying on that NRC document. And NRC document declared NRC document. See, NRC document says declared foreigner, not D-voter. So how do I know? Declared foreigners, not D-voter. You are not understanding, Mr. Sarkar. What we are saying is that NRC document says you are declared foreigner and descendant of declared foreigner. NRC document doesn't say that you are D-voter. D-voter is something else and foreigner is something else. So you don't have any document showing that you have been declared as D-voter. You produce a document. Now you are a foreigner because NRC document says you are a foreigner only. So you'll have to come up with one document showing that like in this voter list I have been declared a D-voter. Otherwise, what direction court will pass without having any document that you have been declared D-voter? You have been declared foreigner, not declared D-voter by NRC. By NRC has only mentioned that you have been declared foreigner. That is why your name is not included in the NRC. Now you'll have to show that you have been declared a D-voter. Now, on what basis you are saying that you have been declared a D-voter? Annexer D is what? Annexer D, where does it say D-voter? Declared foreigner and D-voter is same or what? Declared foreigner and D-voter is same or what? It is not same, Mr. Sarkar. They're two different things. D-voter is something else and declared foreigner is something else. So you'll have to bring in a document which shows that like you have been declared as a D-voter. Otherwise, like what order could this court will pass? You take some instructions. No, that cannot be done here. That cannot be done here. And your prayer is not correct. See, there is a process. I mean, if you want to, if you are a declared foreigner, then it's a different thing. Because you are, since you have already been registered, you are not a declared foreigner, correct? That's what your case. You are not a declared foreigner because you have already registered for 10 years. You can't be a foreigner now. So your name should be there. But you are saying you have been declared devoted. Where? From where you are saying so? And if it is a devoted, then you have to approach the tribunal. Then if you can show that you have been declared devoted, then this court can pass an order saying that you approach. But yet there is no document showing that you have been declared devoted. To remove D, then you'll have to go to the, but in this case, I don't think they'll have to have, no, in this case, I don't think he'll have to go to a tribunal. If it is D also, because that has can be rectified because he has already. So I mean, you either you file a fresh one, bringing in all those records, or we'll pass it over. It takes some instructions. What is there? Because if it is devoted, if it is devoted, then you'll have to change your petition. So what is to be done? We'll pass it over. Okay. On the prayer of Mr. N. Sarkar, the learned counsel, H. A. Sarkar, the learned counsel, appearing for the petitioner, let the matter be listed after a month. Mr. J. Pang is present for NRC and Mr. A. Ali for the Election Commission of India. Huh? Respondent Nawatri is present. So it bring instructions, and if required, you'll have to modify this petition. এখন এটা আমি দিয়ে দেবো মানজনক I heard Mr. MS P. Bora, the learned counsel, learned counsel appearing for the petitioner. Also, Mr. S.S. Roy, the learned, you are appearing as for the state respondents. Mr. S.S. Roy submits that he needs to file an affidavit in the. You have already filed affidavit, Mr. K. Hmm? So 61 WPC 6131 you have not filed. Okay. So both the orders together, submits that affidavit in WPC number 6131 is yet to be filed, and he prays for some time. The prayer is allowed. Let the matter be listed after the ensuing view vacation, so that the counsel appearing for the respondent can file the affidavit in opposition in the instant case. I mean, see, they are praying for filing an affidavit that has not been filed. So let the matter come after the view vacation, because your senior is already not there. Okay. So he has taken a consent, he said. And without affidavit can't be done anything in the admission matter. No, why? I mean, what about the remaining amount? Financial year. They will dispose it of. Hmm? But so you have any instruction? No, admitted is there. Admitted is there. Huh? Hmm? So we'll dispose it of. We within how much time we can pay it? 3 months time. heard Mr. Vijay Mukherjee, the learned counsel appearing for the petitioner. Also heard MS B. Bora for respondent number 2, 3, and 4. Anybody appearing for PWD? PWD, anybody appearing? None appeared for the none appeared for respondent number 1. Also, the petitioner has preferred this writ petition seeking inter alia a direction to the respondent authorities to make payment of an amount of rupees 82 lakhs 53,583, which the petitioner has claimed to be an admitted liability in respect of a contract work, that is widening and strengthening of the road from Angthihara to Bhauraguri Road, full stop. An affidavit in the instant case has already been filed on behalf of respondent number 2, 3, and 4. Wherein 2, 3, and 4, wherein at paragraph 4 and 5, the respondents have stated as follows. Para 4, that the deponent states that the BTC authority has already sanctioned and released an amount of rupees 4 lakhs. Word में भी लिख देना 4 lakhs and rupees 5 lakhs only against the scheme, namely quotation में widening and strengthening of road from Angthihara to Bhauraguri Road, in bracket Bhauraguri to South Musalmanpara Road, bracket complete, from CH 0.00 m small m to CH 4 and 5 यहाँ से देख लेना CH 2350.00 m small m bracket complete under BTC for the year 2013 and 2014, quotation complete, in the financial year 2025-2026 in favor of the petitioner. Then para 5 you write that the deponent furthermore states that the remaining balance amount of rupees 73 lakhs 53,583 words familiar only respectively is under process for making payment to the instant petition hearing, full stop. The learned counsel appearing for the respondents, respondent number 2 and 3, has submitted that they have already released the aforesaid amount of rupees 9 lakhs to the petitioner, and the remaining amount of 73 lakhs 53,583 will be released soon, full stop. The learned counsel for the on instructions submitted. You have got any instructions today? What that last so like whether it can be disposed of like this or not, I mean you will be knowing it. Money is there, sanction is there. She submits that the remaining amount, the payment of remaining amount is in active consideration, and the amount will be sanctioned very soon. Full stop. In view of the aforesaid submission, the learned counsel appearing for the petitioner submits that the instant petition can be disposed of with a direction to release the payment, specifying a period for such payment, full stop. In view of the aforesaid consent, and since the matter is admitted and the release of the amount is in active consideration of respondent number 2, 3, and 4, this court is of the opinion that this petition can be disposed of with a with a direction as mentioned above, full stop. In view of the aforesaid, the extent, it is directed to respondent number 2, 3, and 4 to release the payment of the release the remaining payment of rupees 73,53,583 to the petitioner within a period of 3 months from today. That is on Askadid Day. It is on so and so. No, from today, from today. You are there, no? You are there already, you intimate. From today, full stop. Then the learned counsel, learned counsel for the petitioner will submit a certified copy of the instant order to the respondent authorities for the needful at the earliest. Okay. In view of the aforesaid direction, the instant application is for 3 months you are getting, so he will take maximum 1 week time. That will not make much difference. So we are passing it from today only. Okay, 3 months from today, but he will submit a certificate. No matter, as no matter. I won't very busy problem. I can tell. Okay. Hmm? Who is this here? Oh, but what has happened, Ms. Gayan? Hmm. Hmm. If I an affidavit, if I an affidavit, let me. Mr. B.K. Sen, the learned legal aid counsel, APS for the petitioner, MS A. Gayan, the learned CGC, APS for the respondent. Respondent number 1, 2, and 3. MS Gayan submits that she has received the instruction and will be filing the affidavit in a short time. Prayer is therefore she seeks for some time. Prayer is allowed. Let the matter be fixed after the ensuing leave vacation. Okay, let the matter be listed after 4 weeks. No, she has the instructions. She has the instructions now. Now I have seen this, Mr. BKSN. She will file it. She has the instructions. She will file. She has the instructions now on hand. Well, hmm? Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed after the due vacation. After due vacation, let them file. They haven't filed the affidavit. Who is a senior? Affidavit not filed, corporation department. Hmm? So we'll list it. If they have not filed affidavit, they're seeking some time. So we'll list it after the vacation. Okay. Heard MS so and so, the learned counsel appearing for the petitioner. Also heard Mr. Talukdar. You are appearing for the cooperative department. For Mr. Talukdar for corporation department. Mr. Talukdar submits that prays for some time to file affidavit in the instant case. Let same, no? All the cases are 13, 14, 15, same. 13, 14, 15, same. I have praised for some time. Let the matter of fees after the bigger vacation. Interim order so passed earlier shall continue till the next date of this. Who is your senior? We'll pass it after the vacation. If your affidavit is not there, and they are not be required. You will not file affidavit. Anyway, since he is not there, we'll passing it off. MS so and so, the learned counsel appearing for the petitioner submits praise for some time as the conducting counsel in the instant case is not available today in the court. Mr. S.C. Carroll, the learned counsel. You are appearing for income tax. Standing counsel income tax department is present. Let the matter be listed after the ensuing view vacation. BTC, BTC, you file affidavit? Why you are not taking receiving instructions for such long time? You are appearing for whom? Mr. Deori, whose affidavit is required? Yeah? BTC affidavit is required. BTC is not filing the affidavit. When will you file? After 3 months. Earlier also you have taken time twice. Okay, heard Mr. T. Deori, the learned counsel appearing for the petitioner. Also heard Mr. T. Bharadwaj for 629. And your name, please, madam? So, and so for respondent numbers 2 and 3. And MS so and so for respondent number 1. The learned standing counsel for BTC submits that instructions in the instant matter is yet to be received. Therefore, seek praise for 3 weeks time. Prayer is allowed. Prayer is not objected by the counsel for the other side. Let the matter be listed after the BO vacation. Hmm? Hmm. Hmm. You are appearing for GMDA?
No.
A private respondent. So you have filed another writ petition. Okay, you have filed another. Mhm. But there is an observation that to be both the letters to be listed together. We heard Mr. T. Deori, the learned counsel, appearing for the petitioner. Also heard Mr. B.P. Bora, the learned counsel, appearing for respondent number 5, and Mr. P. Nayak for respondent number. All learned additional advocate general for the state respondents. Full stop. Mr. B.P. Bora, the learned counsel, appearing for respondent number 5, submits. Respondent number 4 submits that the respondent number 4 has also filed another writ petition in the same issue, and the same is pending before this court, and therefore the same should be listed together with this with the instant writ petition, with the instant writ petition. The same being the number 2025. In view of the aforesaid submission, let the instant case be listed along with writ petition number so and so after the due vacation. Listed together, and the same will be listed after the due vacation.
Let me understand. Land acquisition.
Yes.
What has happened, my lord? Earlier there was a series of orders whereby the honorable directed that we should be given the alternative land. They have not done anything. Now, because below the proceeding is pending, by virtue of the no act below, now below
Compensation. Who is appearing?
state and state basically below.
See, it is, I mean, it has been pending for quite some time. I mean, as the issue, I'm talking about not the petition, but the issue. Land was taken long time back, saying that alternate land will be given to them.
Yes.
Alternate land was once found, then again it was cancelled, something like that happened. Then now, since this new act has come, if you are not able to give alternate land, then you'll have to give the compensation.
The month of first week of May also will fix the date of meeting. In the meantime, let them not be affidavit meetings are over. Only thing is, we have amended the petition.
The
Amendment they have not.
they'll have to reply. They'll have to reply.
Whether they give us land or compensate something, it can't be hanging on.
Correct. It's a commercial land. It was a commercial land. So
Some other. They do law. Milord, fix it on Milord, the second week of May, Milord.
second week of May.
It's on 14th of May, it's a Thursday.
14th of May. 14th of May. By the time you file an affidavit, I mean against the amended writ petition. Heard Mr. K.N. Chaudhary, the learned senior counsel, assisted by M.S. Kakoti, the learned counsel appearing for the petitioner. Also heard Mrs. J. Handick, the government advocate for all respondents.
And for a 5, 6, 7, and 8.
5, 6, 7, and 8. Okay, 1, 2, 3, MS so and so, and J. Handick for government advocate for 5 to 8. Full stop. So affidavit will be basically required from whom? State. So
basically, deputy commissioner comes from the revenue department. They are the main.
So both the parties have to file then. So the respondents, in this case, an amended writ petition has already been filed. Full stop. It is already on record. Already been filed. The learned counsel appearing for the respective respondent states submit that they would file their respective affidavits. Affidavits responding to the amended writ petition by the net date fixed. Full stop. Let the matter be fixed on 14th of May. 14th. Yes. Yes. Already released. But the petitioner is not there. So it has gone to DC's office now. The DC has to disburse it. Now, what is the DC's I mean instructions? Hmm. Now he said that there is some subsequent development. That's what mentioned. What about DC's? I mean, whether you have released the amount? Hmm. So we'll wait for some time. Let the council come. We'll pass it over. If it doesn't come, then we'll see what is to be done. Because without him, it will be difficult, no? Because this is there. Or you can keep it like when the matter comes. You have okay. We'll pass it over for time being. Let somebody.
21.
He's appearing from ONGC. So, but ONGC council will be required.
Our appearance is particularly not so important. What is important is important.
ONGC is important. That's what I'm saying.
My lord, why? Because we are the unions.
So you'll be recognized by ONGC only.
His whole case, I know Mr. Saikan, who is that these are three different assets. Gauhati is also to transfer to another asset. So why separate election should not be? Now there is a policy, which is the policy decision taken by ONC. Now ONC will decide as per policy, because in the earlier policy, we said is not challenge to that policy. The earlier policy, we said they are not challenge. Policy says that yes, there has to be one election. Now, as his own papers have been put up, made out before the authority, so they have to take a policy. Unless the ONC is not hurt by this point, he has to, my lord, argue the matter. The ONC. I think
Mr. Saikia, ONGC will be required because I have also seen the matter. ONGC will be required. ONGC will be required. Correct. Reaction is not held. But only thing is then like who is recognized, how it is to be done, that has to be formulated by the ONGC. That is the thing. No? Okay, heard Mr. P.J. Saikia, the Learned Counsel, appearing for the petitioner. Also heard Mr. S.C. Kayal for respondent. Respondent number 10. Respondent number 10. MS K. Budagohai on behalf of respondent number, for respondent number T dash, the learned counsel appearing for the ONGC. ONGC also heard Mr. D Das, the learned senior counsel, assisted by Mr. K. Mohammed, the learned counsel for respondent number 11. Mr. A. Gayan for A. Gayan CCC for 7, 8, 9. Anybody else? No. No. The learned counsel, MS Burgohain, the learned counsel appearing for the ONGC submits that the conducting counsel, Mr. T. Das, is keeping unwell, therefore prays for some accommodation. Let the matter be fixed after the vacation. After the vacation. When? Huh? When? 24 will be will be 2 days. 30th will fix it. 30th is Thursday. We'll fix it. Let the matter be fixed on 30th. Yes, unauthorized construction, what happened? Hmm. You have filed your affidavit and pleadings complete. So what is to be done today? Will you hear it or what?
It can be if therefore declaration that was considered because the presence of the petitioner is not there. It cannot be, in fact, and studies to understand the law. They have already filed their affidavit without imposing a single document.
Okay.
You need to understand me. Before I take you to the bylaws, but the permission will not first where the document. Just take it.
So we are hearing this matter?
Beyond the rules, they have gone.
No, whether you are going to file any rejoinder to their affidavit, because you are saying that no documents have been submitted or something like that. Nothing. So you filed a rejoinder, then and I say this court is ready to hear it. I mean, if the matter can be disposed of without a rejoinder, we can hear it. But if you think that rejoinder is required, so then it's a different thing.
The reply to private response, that will suffice. That is the grounds which are taken are already in the so that the lordship period will also get clear.
So you file a rejoinder to this, I mean, this GMD, I mean, GMD is affidavit.
Boundaries, the setbacks. There is a requirement to that fix. Why you diverting people on file. The fact remains, there is a guideline by the state that 6 feet distance is required to keep that in between the boundary wall and the building. There is a case where there is no
No space was there. I mean, your thing is that now she's saying that like that. I mean, that minimum space that required to be kept. She has kept it under a bylaw which was prevailing at that point of time. At that point, huh? No. You will not file it. Then let's see it.
this finally comes to page 21. Started with 21.
Page 21.
This the FIR. Although this is the FIR initially,
Hmm.
that was the alliance incident control. Construct an RCC building into which water is entering my premises. That night, they carry out blasting of soil. Because stone fall on my house, they are supposed to leave 5 feet in the boundary. By constructing the building, they have left a single. When I informed them about this, they threatened me, they have solved soil. Now, thereafter, I lost the complaint at page 23.
Yes.
This to the incident planner GLC.
Hmm.
Now, thereafter, at page 25, based on my complaint, the notice was issued to the private respondent.
Yes.
Here, certain documents were sought for. LOC, approved plan, document certificate, approved date property tax receipt, and conservation showing.
Now this has been sent to, notice has been given to her,
To the private.
Krishna Devi. Okay. Reply is that?
Was given by the on behalf of the respondent by this government. Was Rambabu Sai to Rambabu Rai stated to be a exhibition. Document submitted in the Jomamandi copy as the receipt DMC, pending permit, DMC property tax.
But is it as per this, the document sought for?
No.
Document sought for was approved plan.
Then the building permit, the building permit, occupancy certificate not given. LGS received a conservation service that was there. Now, pursuant to that, will pending up to case 28.
Yes.
This is the permit. These documents were obtained through RTA. Now, what you can see, second chart, serial number 5, 6, 7, and 8. Now, at the top, lordship sees planning permit issued under Mukhomatri for your Nima Asol. So that has been issued under a particular scheme.
Hmm.
Now, front setback is permissible is 6 meters. For 6 meters column, second column below.
But this is permissible and whatever they have kept, correct? Proposed and approved. And so the approval is as per this.
Yes.
Correct.
This was the approval which was granted prior to the obstruction current. Permissible is front setback is 6 meters.
6 meter, 1.8, 1.8, 1.8 surroundings. Yes. Then this was the approval given to her. Then
building permit in the next page is the same.
Page 29.
29.
Building permit.
It's the same. 1.8 meter will be 6 feet. In this case, the building height may be it is 9.6 feet. This is for G+2.
G+2.
G plus 9.6 meters means G+2. Now, the person who might complain, an inspection was done, so what will find it is 31. This was inspected on P424.
Yes.
Now here the approved washroom is 4, approved is 6, maintained is 6.5. So this is okay. So for rear is concerned, the rear setback could not be measured. So there is no space at the back. Now left is 1.8, there is 0.6, meaning there are two feet.
Okay, 0.3. So this is their inspection, their inspection. Then
Therefore, the next thing for logic is this was the issue.
the notice was issued.
Yes. That's the 37(1). The reply was found to be unsatisfactory. Third paragraph. Therefore, the reply submitted by is not satisfactory. Hence, the notice of the second paper will be not prepared. You are therefore directed to discontinue the undertaking works of election or reaction of unauthorized construction of after value. At your own cost and show cause within 7 days as to why the unauthorized construction should not be done. You know, therefore, no action was taken. In fact, the chart is again given below.
Okay, this was given, notice was given, then
No action was taken. Therefore, you know, I file an RTI. You file page 33. And I just gave you to page 37 for a minute.
so you have RTI for what?
Seeking information. Yes.
Seeking what information?
Yeah. Page 33, page 23 following information. Because they, after issuance of that notice, no further action was taken. Therefore, this RTI was filed. And that question can be come to page 34. That's serial number Roman 4. When the show cause replied, the documents have been submitted by the petitioner upon receipt of letter declaration. DPS, please provide full information regarding the show cause reply with documents. The Rocheville series at page 36 is the reply, starts at page 35.
What is 35?
35 is the reply by 8.
Okay, 36 is the contents.
Yes.
36.
Serial for Rocheville series. But I am 10 Rocheville can take out of the date. This was dated 16 of 10, 2024. The reply.
The show cause notice, whether any show cause reply with documents has been submitted. And this was already, okay, 19.8, no reply was received by them.
I was 1510. What you will see at serial number 4 at page 36, no reply has been submitted.
Okay.
So as well, that's 16/10/2024, there was no reply. This is required, because they have claimed that they have sought for regularization of the deviation. So on 16/10/2024, no reply submitted, no application submitted for regulation of the deviation. Case 37 you will also see. Is the notice under 337(3). 337(3) for demolition.
Notice for demolition.
Notice for demolition. It is undated. Now they claim that this letter was signed but not issued.
Signed by but not issued.
Yes. That is the claim of the GMC operator as well as the private business. We'll also take the third paragraph.
One second. The date is not there.
It is not undated.
Okay.
This is the one you have submitted reply dated 29/2024. That is long back, which is not satisfactory and therefore not eligible. Meaning thereby in between there will be application for regularization. If penal charges for the company.
Now this is which date you don't know.
We don't know. Exactly, but this was signed and this was provided to us by the under the RTA.
After this, what happened?
No further action. Again, we filed an RTA. So 38. No information was provided by the GMC. That is why I insisted on the records. Page 38. Now, thereafter, the note still was filed at page 41. Again, page RTA. No response. Page 44 is yet another RTA. No response. What do we internally come to page 47? That is photographs. The boundary of the plot of land cannot be removed. So what we will see is very clear. There is a ground floor is okay below. Now there is a cantilever projection coming over the wall. How can it be regulated beyond the act, beyond the bylaw?
So that is the status.
Yes. But GNC authorities have filed an affidavit.
What is the additional affidavit you have filed?
The construction was going on now. That was the query of the court. Accordingly, we filed an additional affidavit, we on record the page 53, the running page.
So this was the status in 2025.
Yes. So going on. That is going to be page 53, 54, 55. What you will find the dates there.
Okay, now the what is the reply?
No reply to that below. Now what you will see the affidavit filed by the jails. There admitted most of the things, but page 61, that was 12. Something is amiss. Something is being going on here in that. That is, that will be apparent from the face of it. Paragraph 12 below. That is just to the same thing, paragraph 10 of the EPA. What is under 337(3) was signed by the Commissioner, Gauhati Municipal Corporation, the same was kept in evidence. With the approval of the Commissioner, Gauhati Municipal Corporation, without service of the same to the respondent profile. The reason for such was that the respondent has already submitted representation 5/10/24 before the GLC authorities for regulation of the LS construction. Now, paragraph 13.
One second. So they are saying that like for regulation, they submitted a representation on 5/10/2024. And your RTA was 16/10. Okay, then.
They say there is no nothing as such.
Yeah, that's what I'm saying. Yes.
Paragraph 13
Mm.
the because the statement so the assignment that the judgment for upon receipt of the aforesaid notices or by the claim that the alleged construction of building was started in the year 2008. So from 2008 onwards till 21, there was no building permission. They say construction started in 2008. Permission also 2021. All these years, the building was without construction. That is their admission. That without permission. For Patta land, the permission is required from the GLC authorities. And accordingly, submitted a property tax of so of the year 2008-09. So these are because all semi Patta only team sheet. In consideration of the fact that building construction has started in the year 2008, and all aspects of the building was considered under the Gauhati bylaws 2006, and as such, all the deviation was considered under the Gauhati bylaws 2006, and according to penalty for regulation was calculated, and the respondent of file has already paid the penalty charged for the regulation. Now, that was for a
Yes, provisions of law.
we see. Now, here also we go.
Hmm.
Regulation of what? You know, they claim this is G+2 bill. Permission was of G+2.
And that's what I'm asking. Is there any provisions of law?
Yes, the bylaw says.
Hmm.
Bylaw says 6+2. There is an impact for regulation of deviation when there are 10 in the bylaws itself. Here is the case. There's no permission for G+2. I'll come to it, they consider G+3. When there is a deviation of the building in respect of G+2 itself, then they go for G+3.
But that is not your allegation.
No, that is absolutely coming. Now they say that.
See, your basic allegation is that, like, I mean, whatever the space they should have kept, they have not kept it, correct? So that is your basic allegation, correct? Now subsequently you raise some other thing, other complaints, that's a different thing. But now, as far as this thing is concerned, the space is concerned, I mean, as far as the reply of their GMC's reply is that they have not kept the space. Now, only thing is that, like, whether that can be regularized or not, and whether if it is legally allowed to be regularized, then it's a different aspect. And if it is not, it cannot be regularized, that's a different aspect. Now you'll have to tell me, like, whether it has been regularized as per law or it has been regularized, I mean, irrespective of the law. So that you'll have to place.
They say
Hmm.
the penalty for regulation was calculated and the respondent number 5 has been paid.
No, they have cleared it. They have regularized it. Hmm. Hmm.
Regulation for the third floor.
Hmm.
That is not clear. That is why I said that.
But your allegation is, I mean, for the space, so regularized has to be for that. No, is it your case that the regularization, what they have mentioned is they have regularized about the I mean, height of the building, not for the space. Is it your case?
These things have come up during the course of the case.
Hmm.
Now, this is what has happened. Will see kindly appreciate.
Okay, we'll just come back in 5 minutes. We'll just come back in. Hmm.
I applied for evaluation of the LS construction on 29/24. So here is another date. What are the letters? It contains no one more. So two applications first, and therefore prior to the validation, it is there.
Have they brought on record this letter? Have they brought on record this letter? You have you brought this letter 29/2024? No. Regularization that you have applied for regularization, that letter you have brought on record. Why? No. Have you brought this on record that you have applied for? No. Why? So you have a genuine case. You have applied for this. So where is that letter? The 29/2024 letter. Okay.
That we applied for it, that is not even, they have not been given the date.
Okay, you have then.
The affidavit of the DMC. Now, what will tell you come to the affidavit of the responsibility of file. A65.
Yes. Hmm? 12th line from where? From the top. Hmm.
That there may be some deviation in the structure before. The Beacon had started construction long back in the year 2008 with a bigger income and slowly accommodating the plot since last 7 years. However, it is clarified that the annexure E document, that is the permit, was obtained by the deponent being a layman for abandoned person just to get rid of the complaints filed by the liquidity. As I have never obtained any permission when I started the year 2008. Her case in 2008, she started construction first year. She obtained the permission only because my company building permission was obtained in 2001. I raised the company in 2024.
2021, this thing.
The building permission is 2020.
She started in 2008, but saying that.
Now, case 66, paragraph 8. The she has already replied to the notice the secretary accordingly posted by completion and the department works to gather a fine of 5,89,000 only for compoundable regulation of the regulation. This my whole case rests but this is not compound. On page 67 in that in respect of the avertment made by the friend of the opponent was again served a notice with a notice with a 75/25 asking the opponent because in penalty only for compoundable regulation of the building construction. The opponent immediately on site to deposit the penalty. Now, the query before lawsuit at page paragraph 10. That in respect of the avertment made in paragraph 10 of the repeating as I said there, the section 337 was not received by the opponent, it is claimed to be that the receiving 337(1) to she immediately filed represent before the JMC for execution. This note A, note X. Now, paragraph 11 below. This was starting with the claim of the respondent by as per the notice also is that the alleged construction of the building commenced in the year 8. Now, this was never this step. Even with the JMC authority, there was no letter to that effect. This was further submitted also to skip that part. Now, page 68 below the first paragraph, fourth line starts with according.
Which one?
Page 68. First paragraph below, fourth line from bottom. It started accordingly it is stated. It is said that the penalty for regulation was calculated under the party bylaw. Building bylaws that the was only to pay by them. Now, their performance below at page 72. The receipt. This would be relevant because see the receipt the originally they are page 73. From Krishna Devi so penalty for regulation of RCT G+3. This has come for the first time. This once here I think.
Penalty?
G plus.
Penalty of regularization G+3.
G+3 the permission was for G+2. The lawsuit kindly relate it. That's case 28 and 29. proposed height was 9.6, which is B plus.
Okay.
Now, the page 74 below. This will not be better because you candidate for now. What you will see again a new date 8/10/2024. Your expenses ended 8/10/2024. Send to the respondent number 5. As approved by the Commission of Gauhati Municipal Corporation, you are hereby requested to deposit the finance charges in Tamil so and so for the compoundable regulation of your billing and control query. So whether it is the setback or is it the G+3 construction, that is not clear. The executive number says so, no. The GMC affidavit is silent. Now, 75 is the receipt, no. That is also the regulation G+3. No, thereafter, 77 is the GMC tax receipt of 2008.
Yeah, this is Mukhyamantri Sahaj Griha Nirman Asani. What is that? Two 2014 bylaws. Hmm? The 2014 has been amended or it's a new bylaws altogether? Huh?
Then planning permit and building permit for residential building up to down +2. So what is under?
You're reading from where?
You know, this is the bylaws of the building. In fact,
2290. तो पुराना है नोट कौन सा हो नोट कौन सा हो ना हिंदी की कोई मैं No, but I mean, what is the scheme? Whether the scheme gives some kind of, I mean, leverage, some kind of exemptions or something.
they apply, the application has to be in 30 days. They apply at least time period is short. The window is around 3 days to put it. Provided
That is as per Asoni. As per Asoni, only to facilitate. I mean, in a short span of time. Then nothing, no exemptions about, I mean, boundary, square feet. Hmm?
there are restrictions.
No, you have taken a plea that like that place was you have stated that under the scheme permission can be granted to so and see up to 670 square meters, ground plus two.
Yes.
And you now their square space is 268 square meters. So where is that provision?
Section 9 says all the proposals up to G plus 2 story building up to a plot area of 670 square meters.
Hmm.
Within the what the municipal shall be issued instant delegate building permit and building planning permit.
So it's up to 678.
Up to 670.
And up to 670 G plus 2 can be given. So they have been given G plus 2. G plus 3 later on.
Once you go for G plus 2, the setback it is provided here as well. It has to be 6 feet. It can be regularized to an extent of only 1 feet. So you need to leave out 5 feet of space for a G plus 2 building. Now for a G plus 3 building, the gaps has to be more.
No, correct. Now where is that?
That is I will say. Appendix probably will be the same. Appendix 3.
So bylaws 2020.
It is otherwise the appendix are almost the same.
Same.
Here says setback has to be setback penalties to be levied for violation of the provisions of master plan zoning regime. The floor plans will show setback up to 0.330, meaning there are only 1 feet.
So one feet can be considered and it can be compounded. So that is your thing.
I have brought on documents to show that they have claimed that the possession that is not the fact. Possible of can be that section 9. Key.
Which rule you are reading? Here also is 2014 is only there. Then some amendment of 2020 is there. बेला किताब नहीं है ना? It's not there. Yes, you have another book or? This is Assam Unified Building, Assam Building Construction Act 2010 and Bylaws 2022. Is it so?
Audits were should the this the permissible limit is G+2 cannot go beyond. This is my first line. Second is G+2 the setbacks they are otherwise not qualified. Here 1 feet of space can be left out that can be regularized by way of action. For G+2, the deviation should be more, the setback should be more.
Okay, read from 9:9. The issue of instant Montres or okay, 9 says that it can be given instantly G+2. Then where are those? Which page, which this thing? You take it. The rule 9 says only this thing, instant permit under this G+2, yes. But is there no provision of G+3? And which one you?
You will see, I took the video.
Yeah, 9.6.
1.8.
Hmm.
The question will be
Side and rear open spate to be left around 1.8.
I could be 12.6
Hmm.
plus 8.
Then 2.4.
The requirement is more.
Correct, it will be obviously. Yeah.
So, here in the case, the inspection report says
No. You say I mean compoundable. Where compound?
that is the appendix EB.
Appendix.
E. So, appendix 3. You will see the panel is to be labeled for violation of the objective master.
Where are you reading?
Floor area ratio are extended up to 0.30 meters, meaning they are 1 feet. CD is non-comparable items. Just building. Use of building.
1 second. So 2% is the floor area maximum and setback up to 0.3 meter.
Six is required to be left out 1 minus 1. So beyond 5, it cannot be compound.
Okay. Hmm.
Non-comparable items. Just
Hmm.
serial number 2. Addition of extra floor.
So this is non-compoundable items. Yes.
Just because I have protected on this proceeding, in the condition of the proceeding, they were going on the with the construction. And in the first order, they were allowed to construct subject, it will be subject to the aftermath.
Okay. Then yeah, that I have seen. So your case is that, I mean, this is non-compoundable and that has been compounded. That is your case. And another additional to background now you have taken is that like extra floor has been, and you are not sure whether what has been compounded. Hmm? Yes. Yeah, oh, that's all. Yes, Mr. Nayak.
The inspection possible can you come to page 97. But these the RTIs were not put to. We find in RTI page 95. So the GLT pursuant to that, an inspection was done, page 97.
When it was, when was it?
It was on 19.5%.
Hmm?
19.5%. In the practice of the
Inspection was done by whom?
RCC G+3 building or aforesaid. With returns to the subject, the complaint mission number 16 specifies alleged violation of the construction of the RCC G+3 building set by on receipt of the GMDA, officials observed that setback norms has been violated and construction has been progressed up to the casting of the third floor step. A letter to info was issued asking for submission of supporting documents for the said construction. However, documents have not been received to date.
This 652025 letter. Hmm?
Yes, no, this is 14/6/2020.
No. Page 97.
97.
97 is 65 letter, no?
Page 98. The letter addressed to me.
Hmm?
Page 98 is the letter addressed to me by the GMDA. Copy of the letter number 56. Not received any reply from if everything was fine, what prevented her from replying? Yes, the site was visited and the construction inspected by the KLP officials. Site visit report is annexed as answered. The Lordship will see the report. Your Lordship will have page. Okay. In the brief site visit report, based on the complaint we proceed. This it has been observed that Silver Krishna Valley has construction of G+3 building. Slab casting has been completed up to third floor. Gate work has not been done in this report. Positions are visible on the front and side of the buildings. These side projections significantly reduce the setbacks, resulting in an almost zero setback on the sides. Side parameters observed: front setback 5.28 meters and 3.0 minimum.
Okay. There is admittedly some violations. Now issue is like whether it can be compounded or not, or whether it has been rightly compounded. Yes, Mr. Nayak.
Basics of the complaint, page 27. I don't know where from the prisoner received this copy. Two things document notice. One, no issue number is there, case website. No issue number is there, and no date is there. And most
The issue number is there. There is GPLUC. Huh? 25.
I'm just showing the issue. After 2023, APC.
So you're denying this letter?
I'm not denying. I think from where petitioner received this letter, that is out. Because in the RTI application also, he specifically asked for 3 documents lordship, and if lordship comes to the RTI application, those documents.
Oh, this has already been kept in abeyance, huh?
Yes, that is the stand in the
now you.
If lordship comes to the approval law. Building permission issued by the GMDA authority, that's the case 28. Lordship petitioner, the applicant personality sought for a building permission law. Accordingly, building permission was issued on 01/12/2021. Now, Lordship, where it is written that this is a DA permission for a DA action. This Lordship will see the first line with reference to the above application for layout of development to create DA add to.
So this is a permission, yes, correct.
It's a permission. In my understanding, this is completely new permission.
Maybe, yes.
It may not be for a existing building law.
But they have themselves said that they started in 2008. The building.
That is what I'm submitting. Building was existing there since 2008.
So building started without the permission, that means.
Yeah.
Mm.
That building was started without
Mm.
permission.
But that's what
That
did
is
it.
why subsequently.
No, that was demolished and built again. Mm.
That is why in spite of obtaining this building
Mm.
permission and
Mm.
NOC lordship,
Mm.
in 2024 lordship, they filed an application
Mm.
for regularization of the existing building.
Mm.
This lordship comes to my attention. Page 61.
Now, what has happened to this, all these so-called notice and all?
So-called notices were issued lordship
Hmm.
only in respect of the building permission that was issued on 1/12/2021.
Yes.
Whereas lordship pursuant to this permission lordship, no building was constructed.
No, 1/12/2021 is, I mean, is the permission given, right?
This building permission and this is NOC. DMDA issues building permission.
Correct, correct, correct. Mm.
So building permission was issued in 2021.
Hmm.
NOC was also issued.
Same date.
Yes.
Mm.
But pursuant to
Hmm.
application,
Hmm.
never appeared that building was constructed pursuant to this building permission or NOC. Whereas in the same plot lordship, one existing building was here since 2008.
Mm. Mm.
Notices were issued lordship 337. One notice, that is at page 32,
Mm.
was issued on the basis of this building permission lordship. That is why lordship will say the table lordship approved, maintained.
Mm.
So whatever is there in the building permission, same in the approved column, same parameters lordship will see. Front setback 6 meter. In the permission also it is front setback 6 meter.
And you are therefore directed to discontinue the undertaken works of erection and re-erection of unauthorized.
This notice was issued pursuant to a building permission dated 2021.
Mm. Mm, correct. So what has happened to that now? Now,
By reading page 61 of my
page 61. Yes.
paragraph 12.
Paragraph 12. One second, one second. Yes. Hmm.
Under section 43 was signed by the Commissioner Gauhati Municipal Corporation and the same was kept in attendance. The approval of the Commissioner Gauhati Municipal Corporation. Without service of the same to the respond number 5. The reason for such action was that the respond number 5 had already submitted a representation dated 5/10/2024 before the GMC authority for regularization of the LS construction.
Now, which building is this?
Earlier existing building.
So they have not constructed it.
Pursuant to the new approval lordship, they never constructed anything. So there was a
No, permission you have given to construct what? I mean, permission you have given, approval you have given for what? A construction of a building.
Yeah.
Where they will construct a building? If there is an existing building altogether.
Yes, okay. You will demolish the earlier building and construct a new building. That is why the provision was the erect, re-erect, addition, alteration. Yes, please. So although a building permission was issued, NOC was issued, I don't know why the respondent obtained those building permissions and NOC. Whereas one existing building was already there. Now, lordship, although a notice was issued to lordship on 19/8/2024, that is at page 32.
Now, is it their standard like you will I mean demolish the building and you have applied for this? Then? No, correct. Now he is saying that like the idea was that like it has to be demolished then a permission.
The authority never inspected it. It was applied online. It was issued online. So no inspection was there. No inspection or physical verification was there. She simply applied.
But her stand is that like she is not going to demolish it.
That is not on record.
No, in the affidavit, what she is saying? But now whether, I mean, whether you have in your application, whether you have stated that like we have already constructed a house and we need a permission to, I mean, see, first thing is the illegality you have done that like you have not taken permission while that is admittedly there, right? You are saying that like there's a layman, she could not understand all these things. Now she came to know, huh? No, fourth grade, fifth grade, that is a different thing. That is, no, that is a different thing. Now, Mr. Naik is saying that like permission was given for a reconstruction, for a construction, maybe for a new building construction. So you are saying that, so you are saying that like the old building will be demolished and like new building will be, that is the perception you are, we, it, correct, one building was there. So,
Building Plates were made, measurements were taken in respect of the same existing building.
the old building only.
Old building was there.
So you have given the notice on the old building only.
Yes. Pursuant to the new permission. Pursuant-
The permission to the new permission only, old building only, correct. Correct. Now that, no, since now, old building, no, in the old building only you have measured and like you have done the inspection in the old building and he found that like the old building has some violations and accordingly you have issued notice. Correct. You have issued a notice. So if you have issued a notice saying that, I mean, as per the new law, whatever 2021 permission we have given, as per the permission, you have not constructed the house. So there is some violation. So you have issued a notice. Then done now, as per you now, you are saying that like after a notice was given, she filed an application saying this, saying that it should be regularized or compounded. Was that was kept in abeyance? That was kept in abeyance, you said. That is your stand. Correct. So your case is that she filed a representation. So we have now compounded it.
Next paragraph.
Now you have compounded it, correct?
Yes. According-
Now in the old building, how can you compound it?
Kindly see paragraph 30.
Paragraph 13.
As regards to the environment, yes, it will.
One second. One second. Yes, paragraph 13, yes.
As regards on number 5, upon receipt of the appropriation thesis, served by the GMC had claimed that the alleged construction of the building was started in the year 2008 and accordingly submitted a property tax receipt issued by the Gauhati Municipal Corporation of the year 2008 in consideration of the fact that the building construction had started in the year 2008 and all aspects of the building was considered under Gauhati Municipal Gauhati Building Bylaws 2006 and as such all the deviations was considered under Gauhati Building Bylaws 2006 and accordingly the penalty for regularization was calculated and respondent number 5 has already paid the penalty, sir. Therefore, regularization the building. A lordship authority.
So regularization of the building you have done under 2006. 2006.
The lordship could see the violations of the
2006.
I'm not going to the specific provisions, lordship, because I mean a decision taken by the authority. A lordship, this decision may be right or this decision may be wrong, lord. Lordship will adjudicate whether that decision of the GMC authority for regularization only upon being silenced. That is not under silence law, the regulation.
So you have taken their statement as correct that the building was made in 2008, constructed in 2008, only on the basis of the GMC tax they have paid. GMT tax paid for what? No, no, GMC tax paid for the building. The property tax rate, I mean, I mean, they don't have any permission for the build the property only. The holding is there, the holding is there, but only thing is that like the building is, whether it was there or not, we were not aware, only on the basis of the thing that,
We consider this property tax receipt. Means the GST authority.
which are those property tax receipts? Have you enclosed the property tax receipts? Now, this lady has, I mean, you have done it. Where is that? Hmm. What is the property shown there? No, no, what is the property shown there? I mean, you paid tax for what? See, you have paid general tax 87 rupees. No, no, correct. Now, how can you say that the building was existing there? No, no, receive for what? Receive for what? Property tax what? General tax, water tax, scavenging tax, lighting tax, the property for the floor area, have you paid something? Then, I mean, see, property tax, I also pay property tax. I pay property tax for the floor area, property tax for the building. Where has it shown that like the building was existing at that point of time? No, no, forget about this. What I am asking is that from page 77, you show what is the building is there or not. Then? Where? Hmm. Hmm. House number will be there, but property has to be paid on the basis of the floor area, square feet. Where is that? You have paid only general tax, water tax, scavenging tax, lighting tax, urban tax. Have you paid property tax for the house that was there that we have constructed? From where you can show that like 2008 the house was there, and on the basis of this you are claiming that bylaws of 2006 will be applicable. I think the records will be required, Mr. Nayak. No, no, I think let them produce the record. Let them produce the record. No, no, that's why, Mr. Nayak was saying that like that, see, Mr. Nayak was telling that the records may be required, but you kept on arguing the matter. Now we have found out that like, that then now it is, the record is required after going through this. Then he should have,
109, other interesting. This is the purpose of application for authorization.
10?
109. Now, this also doesn't speak of third floor that get deviation nothing. We give respect, we Krishna Devi has submitted the gas bill drawing as per issue expenditure. Now, what you will see the owner's name signature. And what should we see the water loss number executed by the respondent number 5 when the FADB filed the respondent number 5. Some impressions of there. To what extent, the matter has got the lawsuit can very well equally.
Krishna Devi has a good handwriting, and she has a thumb also. So she either option she can go for. Okay, heard Mr. R. D, the learned counsel appearing for the petitioner. Also heard Mr. P. Nayak, the learned counsel appearing for GMC. You're appearing as an additional advocate general for GMC, and Mr. R. Chaudhary, the learned counsel appearing for respondent number 5. Respondent number 5. After hearing the matter, it is found that it is found that the record in the instant case will be required. Therefore, it is directed that the counsel appearing for the GMDA shall produce the record of the instant case in the next date of listing. Pertaining to regularization, pertaining to the case, I mean, you bring all the record, pertaining to the instant case. So you'll have to give tell the permission relating to the permission of the. Any specific thing has to be written relating to the regularization of the regularization of the house of the building of the private respondent, number 5. No. Let the matter be listed after the vacation. Yeah. No, I mean, let it come, let it come. Let it come. We'll not keep it further. But lot of time we have taken. September you have taken, then 1st of January or December also you have taken. He should not take that much of time. I mean, already. No, at least pleading should be completed by this time, Mr. Das. 2000, I mean, April 2025 notice was issued. Why it takes so much of time? No, whoever after receipt of the notice from the court, the client should be little bit vigilant and file the affidavits in time. Okay, heard Mr. P. Borwa, the learned counsel appearing for the petitioners. Also heard Mr. M. Das, the learned counsel appearing for respondent number 225. And Union Government, anybody appearing? No, none appeared for respondent. Mr. S.S. Roy, the learned CCC appears for respondent number 1. Mr. M. Das, the learned counsel appearing for the respondent number 225, submits that he is yet to receive the instructions and therefore prays for some accommodation so that he can complete his instructions. Prayer is allowed. Let the matter be listed after the ensuing vivification. By the time you file it. When you checked it in 2022. Now you have been asked now presently. No. I mean, present status has been asked. You have not been asked to say what happened in 2022. 2020 report is already there on record. Present status. No, you cannot create that. Like, Mr. Borua, you go to a stone crusher, and when the stone crusher is not functioning, and you submit a report before this court, then it is perfectly fine because on the basis of the report 2022. You cannot force them to person. Then you should have given a notice to them that will be coming on this date, this particular date. Functioning for last 1 month, not functioning for last 1 month. The observation 10 only I have seen, and on the basis of that only I am asking you, a responsible pollution control board goes to a stone crusher to see whether the pollution is there or not, and when they go when this is not functioning. Is this kind of a report? Is this kind of a joke, Mr. Borua? No, is this kind of a joke, Mr. Borua? Then you'll have to die. You cannot, I understand that. I understand that. Then you should have intimated the court that the stone crusher is not functioning. But I could not. Where is the notice that you have given to them? Where is the notice that you have given to them that will be coming for inspection? Where is that? No, more problem is the see, it's a stone crusher. Then
for a day or two, because that point of time will be inspected. It was totally unfunctional because
that you are aware, Mr. Borua. You are very much aware that as far as the pollution status of a stone crusher cannot be measured when it is not functioning. where is the order? Where is the order? No, where is the order? Where is the order? Where is the order? I mean, where this inspection was supposed to be done? Yes, what is your stand on this? Hmm? Hmm. 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 Your crusher is not operating now? Now, when, now it's functioning. Then you should do an inspection now. It is operating now. You go for a proper inspection. Because see, Burwa, I mean, why we are worried about that? I mean, a stone crusher, and like when it is not operated at that point of time, when you went for inspection, then you do a fresh inspection. You do a fresh inspection and give them a notice that will be coming there. And accordingly, do an inspection and submit a report. That will, that will clarify. Hmm. And those other materials, see, other aspects are, I mean, you can measure only when the unit is functioning. Because you'll have to see when the unit is functioning, what is the decibel in the nearest house. That you will find out when the, I mean, machineries are running. When the crusher is not running, you won't be able to make out. And you have given it, I mean, you have given the report on the basis of 21 report. And 21 report at that point of time, it may be correct. It may be within the parameters. But case was filed when? 22. Your report is after, I mean, earlier report I'm talking about. Earlier when you have given the consent. Heard, mister? Yes. See, I mean, they will inspect about the whatever the parameters are required as per the law. Correct? Whatever is there, I mean, they are in the format which has been given the I mean, air and sound pollution, noise pollution act. So whatever the parameters they'll have to follow and they'll have to give a report on that. So if there is some parameter not complied with or not fulfilled, or some parameters they have not measured, which mandatorily they should have measured, then you can point it out before this court. Hmm. Heard, Mr. P.K. Garodia, the learned counsel, appearing for the petitioner. Also heard Mr. S.K. Borua, the learned S. Borua, the learned counsel, appearing for the Pollution Control Board, and MSP Bhattacharya for respondent number 10 and 11. The wide and order dated 16/10/2025, this court has directed the Pollution Control Board, that is respondent number 6 and 7, to carry out an inspection of the present status as far as allegation of pollution is concerned. Full stop. In terms of the aforesaid order dated, in terms of the aforesaid order, The respondent number 6 and 7 has conducted an inspection and submitted a report before this court by way of an affidavit. Full stop. The inspection was conducted on 12/11/2025. However, from the inspection report, it is found that while the inspection was carried out, the the stone crusher was not operating, and it was under breakdown for few weeks. Full stop. Therefore, the report was basically made on the basis of previous air monitoring and noise level monitoring report dated 19/2022. Full stop. Since the allegation basically about noise and air pollution, which actually happens when the stone crusher is in a operational mode, this the report submitted by the Pollution Control Board is not sufficient. Full stop. Therefore, it is directed that the inspection to be carried out by the Pollution Control Board has to be done when the stone crusher is in operation. Therefore, it is directed to the Pollution Control Board that a notice of inspection should be issued to the respondent number 11. Respondent number 11, that is the stone crusher, beforehand, at least giving them a week's time, and thereafter carry out the 10 and 11, giving at least 1 week's time, and thereafter carry out the inspection. After the inspection, a report needs to be submitted before this court by way of an affidavit. Let the matter be listed after the ensuing behavification. By that time, the report of the Pollution Control Board should be submitted before this court. Should be submitted by way of an affidavit before this court. So you carry out an inspection when the functioning. Yes. The affidavit not filed. You file an affidavit. You already taken time earlier also.
Was there, but as per record is saying they participated in the election.
Okay, you file an affidavit because this will be a contesting matter, so you'll have to file an affidavit in the case. I heard Mr. A. Konikar, the learned counsel appearing for the petitioner, also heard Mr. S. Datta, the learned standing counsel PNRD department. Mr. S. Datta submits that he has received the instruction in the matter when will be filing an affidavit shortly. Full stop. He prays for 2 weeks time. Prayer is allowed. Let the matter be listed after the ensuing view vacation. You take this and file an affidavit, no? After the view vacation. Yes. Readings complete. You ready for hearing? Mr. Chaudhary?
It will take some time.
Take some time. Okay, the right pleadings are complete in the matter. On the joint prayer of the learned council appearing for the respective parties, let the matter be fixed after reopening.
On 28th.
Let the matter be listed for for admission hearing on 28th of April, 28th of April. If, record the names, Mr. R. Chaudhary. You are assisted by Mr. R. Chaudhary, assisted by Borua, P. Borua, and write his name also. This one now 5. Just record the names.
29.
Okay, heard Mr. So-and-so, learned counsel paying for the petitioner. Also heard Mr. S.S. Roy, learned. You are paying for as a government advocate? Learned government advocate for the respondents. His learned government advocate submits that instructions have already been received and he will file the affidavit shortly. Let the matter be listed after the verification. Hmm? Okay, heard Mr. So-and-so, the learned counsel appearing for the petitioner. Also, M. Borgohain, A.K. Bhuya. Your BTC? A.K. Bhuya, the learned counsel appearing for the respondent numbers 2, 3, and 4. MS so-and-so submits that affidavit is ready when will be filed during the course of the day. Let the matter be listed after the view vacation. After the view vacation. Let them file the affidavit. If you need to file and reply, you can file.
Madam 52.
They took some time to, for instance, what? You don't have an abscess. 11 for who is appearing for 11? Huh? No, I mean, last time we heard him. We indicated that we are allowing this application. What? You know, last time when the matter was here, he was appearing in VC, right? Huh? I'm not getting you what you're saying. He appeared in VC or through VC, right? Yes, then. The last time we indicated that we'll be allowing this application. What is there not to allow this application? What is the instruction? Hmm? No. So what is there to reply? I do not understand in this matter. Then he should have been here. No, he has prior engagement. This was also fixed on a fixed date. It was not like that somehow it has, it has been listed, without giving a date. Date has been given. Okay, Mr. Nag will put it. They are having Heard Mr. P. Nayak, the learned counsel, appearing for additional advocate general, appearing for this, for the petitioners. Also heard here, your name? So, for respondent number 11. And Mr. So number 8, Mr. A.R. Gogay for respondent number 226. You don't have any issues. Tamil Nadu, you don't have any issues. Mr. P. Mohanta for number 9 and 10. Hmm? No, I'll do that. MS so-and-so, the learned counsel, appearing on behalf of respondent number 11, submits that they would like to file an affidavit in the instant case and prays for some time. Full stop. The state of Tamil Nadu, represented by Mr. Gogoi, submits that he doesn't have any objection to the IA filed by the petitioners. Full stop. In view of the prayer for time by respondent number 11, let the matter be fixed when? After vacation. But there is nothing in this matter to object. I mean, okay. Let the matter be fixed on 30th of April. 30th of April. 30th of April. Yes.
Department of Revenue, KS and Production. This order was passed on the basis of a direction of.
You were supposed to take some instructions. So what was your instruction?
Allowed to file an appeals notice.
I mean, there is no point keeping this open, keeping this, because there is an alternative remedy. Correct. Then you can go there.
Agree can file before the agreed member inserts cardiolum of a person. And we decide that. And file that in a period of 10 days.
You have filed an affidavit over already. You have filed an affidavit. It is for cancellation of patta. Hmm?
Number 10 to 14, right?
Okay, right. Heard Mr. P. Bordolo, the learned counsel, appearing for the petitioner. Also heard Mr. J. Chutia, the learned counsel, appearing for respondent number 527. Also heard Mr. B. Chakraborty for respondent number 1. Oh, you have a private respondent. 10 to 14. It is so and so for 1, 2, and 8. Mr. N. Goswami for 3 and 4. You know, the petitioners are the president and secretary of the Lunse Ronghang Village Development Committee and committee full stop. A plot of land measuring 17 bighas covered by DAG number 75, comma, patta number 14, comma, Longparpan village, comma, Duar, Duardisa, Moja, comma, Fuloni Revenue Circle District Karbi Anglong, comma, Assam has been using by the villagers as a cremation ground for the last 50 years. National Highway Authority of India has undertaken a project of four laning in the NH 29 from Parkhowa to Lahorijan, and for the aforesaid purpose, NHAI had acquired the aforesaid land, and in this regard, a notification has also been issued on. It has been taken by respondent number 2 or respondent number. But you have written it NHAI. Anyways, NHAI DCL, for that purpose, NHI DCL, that is respondent number 8, had acquired the aforesaid plot of land, and in this regard, a notification was also issued on 26/5/2020. It is the contention of the petitioner that after the issuance of the notification, the respondent numbers 10 to 14 had illegally taken possession of a portion of the aforesaid land, and which can be seen from the report dated 16/11/2021 submitted by the respondent number 9, that is the Assistant Revenue Officer, Fulani Revenue Circle. Full stop. In view of the aforesaid illegal possession of the land, the petitioners approached this court by filing WPC number 1583/2022, and the same was disposed of by order dated 10/3/2022, directing the petitioners to approach the concerned competent authority of the land acquisition for redressal of their grievances. Full stop. Pursuant to the aforesaid order dated 10/3/2022, the petitioners approached the respondent number 7, that is the Joint Secretary Competent Authority for Land Acquisition, in bracket CALA, bracket complete, Revenue Department, Karbi Anglong Autonomous Council, DFU, Karbi Anglong, vide their representation dated 22/3/2022, and subsequently submitted another representation dated 21/10/2022, whereby they had prayed for cancellation of allotment of the portion of land to the respondent number 10 and 14. The aforesaid representation was registered as a case and numbered as land complaint case number 4/2022. However, since nothing has been done in the aforesaid case, the petitioner again approached this court by filing WPC number 2324/2024, wherein this court, by its order dated 8/5/2024, directed the respondent number 7 to dispose of the land complaint case number 4/2022 by passing a speaking order after giving opportunity, after giving due opportunities to all the stakeholders, including the petitioners within a period of 2 months. However, since nothing has been done in the, nothing has been done in terms of the order dated 5/8/5/2024, the petitioners had filed a contempt case number, contempt case, that is contempt case number 425/2024, which is still pending, huh? Contempt, contempt case number so and so. And when was it disposed of? And why and order dated 14/8/2024, this court has disposed of that, disposed of the contempt petition. Hmm?
The representation was disposed of by the Joint Secretary Kadam Mayor on 14/8/2020.
But because of that, the contempt was disposed of. Contempt was disposed of due to the fact that, respondent number 7, had already disposed of the land complaint case number 4/2022 filed by the petitioners. Full stop. Full stop. One second. After the aforesaid rejection order dated 14/8/2024, the learned, the petitioners have approached the respondent number 6 on 30/9/2024 by filing an appeal. However, since nothing has been done in the appeal, the petitioners have filed the instant writ petition. Full stop. The learned counsel, learned standing counsel appearing for Karbi Anglong Autonomous District, Karbi Anglong Autonomous Council submits that there is, and submits that under Rule 26 of settlement rules. Will you write that? Submits that under Rule 26 of settlement rules, an appeal lies against the order of cancellation of patta, before the executive member in charge of in charge revenue, Karbi Anglong Autonomous Council. Full stop. Therefore, he submits that since an alternative remedy is already there as per the statute, as per the rules, the petitioners should be directed to prefer an appeal before the aforesaid authority. Full stop. The learned counsel appearing for the petitioner has also fairly submitted that he would prefer an appeal before the aforesaid authority. Full stop. In view of the aforesaid submissions, the instant petition is disposed of with the direction that the petitioners shall submit an appeal before the member secretary department, before the secretary. I'm sorry, before the executive member in charge revenue, through the respondent number 6, that is the Secretary, Department of Revenue, Karbi Anglong Autonomous Council, and thereafter, within a period of 2 months from the date of receipt of the appeal, the authority concerned shall dispose of the appeal as per the law. Full stop. Full stop. That's all. That's all. The appeal will be filed, opportunity will be definitely given to you. 2 months. 2 months. No, but 2 months from receipt of your appeal. So I have given, I mean, so as soon as you give, your appeal will be heard expeditiously. So disposed of.
54 and 55.
Service is complete. Respondent number 8. Complete. Okay. Now, I mean, let them file an affidavit. Heard Mr. So-and-so, the learned counsel. There are two matters over. It's outstanding bill only. You are paying for? Why? So what, why? Why you have made them party? Name is where? Why have you have made them parties? Now, you have done some work, right? Huh? Correct. So you have done some, so you have given some services to education department. And education department did not pay you the money. How is this is involved? Well, let it be. Let it be. Hmm. Okay, heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard MS So-and-so, the learned counsel. You are standing counsel, madam? Standing counsel for secondary education department. And Mr. B. Sharma. 54 you were there. 55 you are not there. Okay, 54 you first, right? Sharma so-and-so. For accountant general, no? For accountant general, respondent number 5. The learned standing counsel appearing for the secondary department submits that she is yet to receive the instruction and prays for some accommodation in the matter. Full stop. The learned counsel appearing for the accountant general submits that he doesn't have any role to play and therefore his name should be struck off from the instant petition. Full stop. Petition, to which the learned petitioner submits that that he has been made a party. He has the respondent of 5 has been mistakenly made as a party and his name can be struck off. Full stop. 2 weeks time is granted to the council, standing council appearing for the secondary department to file an affidavit in the instant matter. Full stop. In view of the submissions made by the council appearing for the AZ as well as the petitioner, the name raised to strike off the name of respondent number 5 from the instant writ petition. Let the matter be fixed after the ensuing due vacation. Let the matter be fixed and give a date on 30th of April. And same order, and only Mr. Chakraborty will be appearing for respondent number 5. And there also your name will be struck off. Sorry. And this matter also on 30th, both the matters.
$56.
Affidavit not filed. Hmm? So is it, Mr. Doctor, it is ready over?
One is praying immediately after the matter. If we will not file, also file an offense because they file additional affidavit.
Not here. That's as far as 30th of June.
30th of June.
Yes, ma'am. But we should final documents filed of that private response.
So we'll do one thing, madam. I mean, immediately after reopening, we'll fix the matter. We'll hear the matter and dispose of. Because if he doesn't file affidavit also, we'll go ahead. We'll go ahead. Heard MS SB Chaudhary, learned counsel for the petitioner. Also heard Mr. S. Datta, the learned standing counsel for PNRD department for respondent numbers 1, 2, 3, 4, 1, 2, 3, 5, and 6. 5 and 6. 5 and 6. And you asked for respondent number 7, full stop. Mr. S. Datta, the learned counsel for PNRD department, submits that he should be given a last opportunity to file the affidavit in the instant case, full stop. A last opportunity is given to the standing counsel for PNRD department to file an affidavit in the instant case, full stop. Let the matter be listed on 23rd of April. 23rd of April, an endeavor will be made to dispose of the matter on that date, on that day.
Item 20.
Yes. The number, no, nobody is appearing. She has given an instruction saying that it has gone to DC. You are appearing for DC. So you release the money. Hmm? Hmm? So, within 3 months will be quite, I mean, long time. I mean, we'll give an after 5th of May. So 2 months, 2 months, 2 months. We'll dispose it of in terms of your instruction, and within 2 months, the payment will be done. But nobody is there. So how no, correct now. Now how they will get to know about this, the order, passing of the order? Mr. A.K. Das. Anybody knows A.K. Das? It's 1411, no? It's subsequent to this. Should we place in place? I mean, place it in the next week. I mean, should we wait for this? Because otherwise, how they will get to know? I don't know whether this is received by them or not. I mean, if they do not get the information, we dispose of the matter. We'll fix it in this week only, sometime in, I mean, 7th will fix it, 7th will fix it. 7th, if it doesn't come, then we'll see what is to be done. Nobody. Then that order can be done. Or should we, I mean, do something like that? That you will intimate him, will dispose of the matter. Deputy Commissioner's Office. Okay, I mean, none appeared for the petitioner when the matter was called for. Though MSMD Bora, the learned standing counsel for Transport Department, is present along with Mr. So-and-so, the learned counsel, appearing for the Deputy Commissioner. Deputy Commissioner of which district? Dibrugarh. Deputy Commissioner of Dibrugarh. In the interest of justice, let the matter be fixed on 7th of April. 7th of April will MS so-and-so appearing for respondent 1, 2, 3. Last time also it was not available. Okay, we'll fix it in the fix it on 7th. We'll fix it on 7th. CD in the instant case is yet to be received. Later matter will be listed on 7th. Parties are duly represented.
33. Order.
It's complete. The service of notice on respondent number 4 is complete. Complete as per the Loazima as per the Loazima Court order dated 19/3/2026. Matter is ready for admission hearing. Later matter will be listed on admission hearing after the ensuing big vacation.
Hearing on 12th of May.
12th of May. Okay, let the matter be fixed on 12th of May. Mr. M. Sharma, no? M. Sharma for the right.
34.
Okay. As per the Loazima Court order dated 23/2/2026, the service on respondent number 7, 8, and 9 are complete, and the matter is ready for admission hearing. Parties are duly represented. Let the matter be listed after the due vacation. Cease for respondent number 6, 1, 2, 5, and take his name. Why it has come for orders? No, it has come for orders. Why? No. Why this matter has come for orders today? It should come for our admission hearing then. Why it has been listed on the order? Yes. Yeah, I think the service is complete. Pleadings are complete. Hmm? Hmm. Okay, sir. Okay, you're right. Heard Mr. R.C. Saikia, the learned counsel appearing for the petitioner. Also heard Mr. So-and-so. You have filed your affidavit. Are you filing reply? So you are not filing reply. Okay. Mr. R.C. Saikia, the learned counsel, submits that he would like to file a rejoinder in the instant case and therefore prays for 2 weeks time. It will be 2 weeks time. Let the matter be listed for admission hearing after the reopening. Okay. Okay, I will hear it in the admission hearing. Let the matter be listed after ensuing view vacation. Yes, sure. No, because we will have to file your rejoinder. You file the rejoinder, your rejoinder is there, matter will be heard. Yes, definitely. An endeavor, you're right, an endeavor will be made to dispose of the matter on the next date of listing. If pleading is complete, you don't. 37, anybody appearing? Finance department, anybody? Mr. Roy, anybody is there? Finance department? All your esteemed colleagues, nobody is there. You are appearing for whom? One is who? So one is Mr. Pegu. You are appearing for Mr. Pegu. And respondent number three is the person, right? Who has to pay? The money has to come from the home department. Okay, we'll post it after the vacation. Let them come. Heard Mr. So-and-so, the learned counsel appearing for the petitioner. And Mr. On behalf of D not for respondent number 1. Respondent number 1, none appeared for respondent number 2 and 3. Huh? You are appearing for whom? 1 and 3. So what is the instruction then? What is your instruction? I thought you are appearing only for 1. You are appearing for 3 also. So what is your instruction? Huh? Mr. Nath, you're not paying your colleague. So when next when? So we'll put it on when? May. We'll put it in the month of May. You have already received, I mean, huge amount of money. Okay. Mr. DK Nath for, you are appearing for 1 and 3. 1 and 3. And Mr. Chaliha appearing for? This one and number 2. Mr. Nath submits that substantial amount of money has already been released and the remaining amount and the endeavor is going on to release the remaining amount of money also. He prays for listing of the matter in the month of May. We'll stop. Let the matter be listed in the month of May. None appeared when the matter was called for. None appeared for the petitioner when the matter was called for. Do Mr. J. Hendick, and G. Hazorika, the counsel appearing for the respondents, are present. I think no steps have been taken. Now, the next time then we'll have to dismiss it. Hmm? Heard Mr. Your DC Kalita, the London counsel for the petitioner. You are. Why are you not filing affidavit? When? You took almost 3 years, 2 years to file affidavit. Always you do that. Okay, MS Thapa, the learned counsel appearing for S. Datta. Appearing for S. Datta, learned standing counsel for PNLA department. Prays for 3 weeks time to file affidavit in the matter. Prayer is allowed. Let the matter be listed after 4 weeks. Mr. Nath, you have submitted certain instructions last time probably. Some instructions are there, I don't know. So you file an affidavit then? Or what? I mean, whether it can be disposed of like that? To join inspection. One second. So, I mean, what about compensation? Okay, then let them have it because I mean, you are concerned with your compensation, right? So nothing has come as far as the compensation is concerned. They have done a joint inspection. They have found that certain land may have been utilized by, so they'll have to come to concluding, I mean, come to some kind of conclusion that. So I heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr. D.K. Nath, the learned counsel appearing for respondent number 2 and uh, respondent number. Okay, and who is appearing for Secretary Revenue and Sales? Nobody is appearing. And Sales, anybody is appearing? Dimahasao? None appeared for respondent number 1. Full stop. Mr. Nath, the learned counsel appearing for respondent number 2, submits that he has received some instructions as instructions uh, as to as to as to um, as to conduct of a joint inspection as in terms of the order dated 2011-2024. However, he submits that as far as the issue of compensation is concerned, he doesn't have complete instructions as yet. Therefore, he prays for some time. Let the matter be listed after the BU vacation. You keep it with you. I mean, next date you can complete your instructions and put it. Let the matter be listed after the BU vacation.
43. That is I am in this case. Petitioner and
Hmm.
representing to their legal head by the petition during the pendency of this petition, main petition, the concerned circle is
Hmm. Now, why this IA is filed?
This mutation of the personal caused by the concerned circle, but direction to the request.
Now, how can that direction can be given by this court? Modification? No, who is appearing for the other side? So what is your contention in IA? You don't file an affidavit. You file affidavits. I mean, IA is filed. I mean, they want a urgent order and like you don't file any affidavit. You don't have any instructions. Now what will you do? Let them file an objection or whatever they want to file or bring your instructions. He is praying for modification of the order. Right. Heard Mr. J. Hamad, the learned counsel appearing for the applicant. Also heard Mr. So-and-so, learned government advocate, government advocate for whom? As for number 2 and 3, you are appearing? As for number 1, as for number 1. Mr. So-and-so, learned J is government advocate, submits that he would like to file an affidavit in the instant IA that has been filed by the petitioner. Full stop. Therefore, he prays for 2 weeks time. Time is allowed. Let the matter be fixed after the BU vacation. Yeah, BU vacation. Not possible. So many matters have been fixed. So many matters. Date then it will go to May. Oh, full booked. Mr. Hamad full booked. It won't be possible. First week of May. Okay. Fix first week of May. Let it be fixed on 7th of May.
44.
Service is complete. Huh? You file an affidavit. Respondent number 3, you are appearing. So you have been served justice. Okay, parties are duly represented and duly represented. Full stop. Let the matter be fixed for admission hearing after the due vacation. Affidavit, file an affidavit. Why? Pink flag noise is what? Hmm? Yes. Hmm. Yes, you have you have to withdraw the appeal. Hmm? No, no, what is remaining now? Okay, let it come, let it come after the view and okay, but let the matter be listed after the view vacation. Services parties are duly represented. The matter is after admission hearing. The interim order so passed earlier shall continue till the next date.
45.
Hmm? Okay, this matter, okay. I will not be able to, I will not take any time. I was representing, I mean, not, I was opposing this case. Department, okay. Let the matter be placed before another bench, before an appropriate bench except me.
47.
None appeared for the applicant when the matter was called for. Let the matter be listed after the due vacation.
Forty-eight.
So you have received the amount,
No.
then what happened? Huh? No, no, you have filed this for what? Huh? Huh? Correct. So you have received the amount. Oh, I mean, you are one of the petitioners, right? Hmm. You can so. You had heard, Mr. You are Mr. So and so, the learned counsel appearing for petitioner appearing for the applicant. Applicant, namely Mr. Dipsuti Kolita. Mm, Also heard me MS 3 and Mr. So SK Hazurika for 6 and 8. 2, respondent number 2. Full stop. The instant application, instant IA has been filed in the writ petition in the connecting writ petition number 2729/2023, praying for deletion of the name of the petitioner. Your petitioner number what? Petitioner number 9 in the aforesaid WPC, in the connecting WPC 9, due to the fact that the petitioner has already received the claimed amount. Due to some due to certain settlement that has been reached, that has been arrived at between the respondent authorities. Full stop. Full stop. The learned counsel appearing for the respondents do not have any objection in deleting the name of the present applicant, that is petitioner number 9 from the connecting writ petition. Full stop. In view of the aforesaid, the instant IA is disposed of with a direction to the registry to delete the name of petitioner number 9 from the connecting writ petition, that is 2729, WPC number 2729/23. Service complete. So admission hearing, huh? As per the office note dated 26/3/2026, the service upon respondent service of notice upon respondent number 5 and 6 are complete. Let the matter be listed for admission hearing after the ensuing view vacation. You write down the name as K.M. Hassan for the petitioner and Mr. S.H. Hazarika for S.K. Hazarika from respondent number. The same order will go in the other one. Interim order so pastoral will continue. Then item number 52 also same, right? No, 49, and 52 same order. Same concept. Same this thing, no? Respondents number same. Okay. Same order. Both the matters to be listed together. No?
51.
None appeared for the petition. None appeared for the petitioner when the matter was called for. For the interest of justice, let the matter be listed after the view vacation. 33 interim order.
Okay.